Not the problem. Yes. Screen में slide में yes.
Good morning, everyone, for this on this webinar. So this webinar is about appreciation of evidence by Honorable Justice Pradeep Nandrajog, sir. First of all, I would like to thank everyone, all judicial officers across India who have registered for this webinar. We have received almost close to 4,000 registrations, and now sir would be addressing almost 4,000 judicial officers across India. It's a technology that we are using that we can reach out to public at large. On this webinar, this session will be divided into two parts, wherein Nandrajog sir will take the session. It will take almost like 1 hour plus, and in the last, we will have a question answer round. So I would request all the attendees and the participants to keep the questions till the last. And once we announce that the question answer round is open, you can then post your questions and it will be taken individually. On this webinar, we have Yellagada sir, Sudhakar Yellagada sir, who is Joint Director at Maharashtra Judicial Academy. And we have Sir, Honorable Sir Pradeep Nandrajog sir. So I will request Sudhakar Yellagada sir to please welcome Sir for giving us time for this webinar and agreeing to come online for this particular webinar. And now I will just request Sir Yellagada sir to please introduce Honorable Sir. Yellagada sir, please. Thank you.
A very good morning and welcome to all honorable guests. It's my honor to welcome all of you. Today's guest speaker, Honorable Chief Justice Pradeep Nandrajog sir, and Honorable Chief Justices, Honorable Lordships and Ladyships from India and Sri Lanka, and Honorable brother and sister judges from all over India. In the beginning, I'm very thankful to our collaborating team from the SCC Online for making available this platform, and with the inspiration given by our Honorable Chief Justice and Patron-in-Chief of our Academy and our Honorable Officiating Director, we have started the webinars, and this is the second webinar. And for this webinar, it's my pleasure and honor to welcome Honorable Chief Justice Pradeep Nandrajog, former Chief Justice of Rajasthan and Bombay High Courts. His Lordship was born on 24 February 1958, did BSc in 1978 and LLB in 1981 from Delhi University. His Lordship was enrolled with the Bar Council of Delhi in 1981 and started practice on almost all the sides. And his Lordship was standing counsel for the Election Commission for 2 years, apart from being a standing counsel for 6 years for the Delhi Municipal Corporation. His Lordship was elevated on 21st December 2002 as an additional judge of the Delhi High Court and made a permanent judge on 16th April 2004, and his lordship was elevated as the Chief Justice of Rajasthan High Court on 2nd February 2017, and we were fortunate to have his lordship as our Chief Justice of Bombay High Court on 7th April 2019, and his lordship retired on 23rd February 2020. My lord, you are welcome to our academy and to this webinar. And I must say that at the time of his lordship's retirement, his lordship has promised to make his services and knowledge available to all over the India for the judges, and especially promised to devote his time to these to our academies also. Thank you, my lord, and this is the beginning. And may I again once again welcome your honor and make a request to start the session. Thank you.
Sir, your line.
Good morning. I'm having my mobile phone in my hand, and as I swipe the screen upwards, I see three icons. The first shows the screen time and the second is interesting. It's podcasts and it reads, "You're all caught up." Yes, you are. Good morning. I'm sure all of you must have heard about the great painter Jean-Léon Gérôme, who in 1896 had made a painting of a nude image of a male stepping out of a well. The painting was named "The Naked Truth." It represented the story of an interaction which Truth had with Lies one day. Winters had just receded and some spring had set in. Truth decided to come out of the well and take a walk in the meadows. He encountered Lies. He recognized Lies and was wary of Lies. And Lies greeted Truth and said, "Hello." Truth replied back, "Hello." Lies said, "It's a wonderful day." Truth was very wary of Lies. He looked up the sky. It was blue. The sun was shining. The bees were humming. The butterflies were flying. The birds were chirping. So all empirical evidence suggested that it was a fine day, and Truth said, "Yes, it's a fine day." As they walked towards the meadow, they came across a stream. Lies put its foot in the stream and told Truth, "The water is pleasant, it's not cold, let's have a bath." Truth was wary of Lies. He tested the water himself. Finding that the water wasn't too cold, he decided to take a bath in the stream. Truth and Lies removed their clothes, and as they entered the stream, suddenly Lies sprang out of the stream, picked up the clothes of Truth, and ran away. Truth had to retrieve his clothes and walked out, searching for Lies, and he realized that the world, seeing the Truth naked, turned its gaze away with contempt and rage. The poor Truth returned to the well and disappeared forever, hiding therein its shame. Since then, the Lie travels around the world dressed as the Truth, satisfying the needs of society, because the world in any case harbors no wish at all to meet the naked truth. In spite of this reality, judges have to perform the task of finding out the truth. And this has to be found in the maze of material presented to the court in the form of what in legal parlance is called evidence. If you look at jurisprudence, Bentham said evidence is any matter of facts, the effect, tendency, or design of which is to produce in the mind a persuasion, affirmation, or disaffirmation of the existence of some other matter of fact. And we find that under the Indian Evidence Act, when we look at the definition of the word evidence in section 3, it mirrors the jurisprudential concept of evidence as was spoken of by Bentham. As it is said by jurists, that absolute proof is a myth and all perfection is fake. Therefore, law settles for the probability of the existence of truth as a good substitute, and we find this mirrored once again in the definition of the word proved in section 3 of the Indian Evidence Act, which says a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. The problem lies in the fact that evidence, by its very nature, be it documentary or ocular, is tendered by humans. Facts which are perceived by humans are processed and sieved in the inner recesses of the mind, thereby distorting the purity of the fact perceived. To illustrate, let's take in a case of a road accident at a T-junction. A is the witness. His presence at the bus stop at the T-junction is established. That the accident took place when he was present is also established. And the issue is, how did the accident take place? Now, what really happens is that A is not staring at the spot where, let's take, the scooterist and the fellow on the motorcycle collided. Ever see individuals at bus stops? They're munching something, they're thinking something, they're looking at the sky, they're looking at the bird. Something or the other has caught their eye, and when they hear the bang, suddenly their attention is drawn to the place from where the bang emanated. And looking at the position of the scooter and the car, they start analyzing and perceiving in their own manner as to what could have happened, probably overlooking the fact that a small puppy was passing by the road. The scooterist, to save the puppy, veered his scooter towards the right. The car driver was taken unexpected by the scooter suddenly swerving to the right, and the accident having taken place. Long time back, when I was a student of law, I chanced upon this book in relation to the origin of rules of evidence which require the application of the methodology by which evidence is to be appreciated. It's called The Origins of Adversarial Criminal Trial by John H. Lambeg. He authored this book with respect to the trials which used to take place in the assigned courts in England in the 15th and the early part of the 16th century, and pertaining to deposition of the witnesses. The learned author brings out something which is extremely relevant for any trier of a fact even today. The reason being that law and jurisprudence defines a fact to mean a thing, a state of thing, a relationship of thing which can be perceived by the senses, and a mental condition of a person. Now, we all know that we all have 5 senses and we perceive facts through the 5 senses. And as I already said, that whatever is perceived is processed in the internal recesses of the human mind, and that is where the taint comes into what a man perceives vis-a-vis what he sees, vis-a-vis what he speaks. The book highlights that in very few instances do people really know what they speak. It highlights 3 things. Firstly, don't assume that people tell the truth. It brings out, secondly, people mix their perceptions with what might have happened when they see a thing. Thirdly, the book brings out that it is dangerous to assume that people can be trusted to behave in a rational way. Apart from the 3 problematic traits which humans exhibit, the book correctly brings out 2 striking defects. And I could do no better than to read a little extract from the book itself. It talks of the adversarial procedure which is followed in courts where rival parties are presenting their versions, and the learned author talks about 2 effects which are striking defects which are produced. The first, he calls it the combat effect, and the second, he talks about the wealth effect. By the combat effect, he refers to the truth impairing incentives in the adversarial systems where nobody wants the truth to be brought out. And in a joking manner, once speaking at the Judicial Academy in Maharashtra, I said, look, the plaintiff wants a decree, the defendant wants the suit to be dismissed. In a criminal trial, the prosecution wants a conviction, the accused wants an acquittal, the judge wants an disposal. Nobody wants justice, and yet we keep on talking of justice. Back to the learned author. So he says that the combat effect means winning often entails tactics that distort or suppress the truth, for example, concealing relevant witnesses to affect the testimony at trial, coaching, and engaging in abusive cross-examination. By the wealth effect, the learned author obviously referred to that if at a trial, be it a civil or a criminal, one party has an economic wealth much more superior to the other. Because of this fact, the skilled trained counsel is able to blunt or hide the truth. The book brings out something very interesting, that in the field of law of evidence and appreciation of facts, way back in 1790, and I'm quoting from page 247 of the book, in the King's Bench case, Chief Justice Kenyon said, and that is the core of appreciation of evidence, all questions upon the rule of evidence are of vast importance to all orders and degrees of men. These rules have been matured by the wisdom of ages and are now revered from their antiquity and the good sense in which they are founded. There is no law of appreciation of evidence other than what the learned Chief Justice said in 1790, good sense application on a rational way. 4 years later, something very interesting, Edmund Burke was called upon by the Queen to address the Parliament, inasmuch as the parliamentarians in England wanted to know what were the rules relating to appreciation of evidence. They had asked Edmund Burke what time would he need to appraise the members of Parliament about the rules of evidence, and what Edmund Burke said in response at the House of Commons, I would read. He said, "The law of evidence is very general, very abstract, and comprised in so small a compass that a parrot he has known might get them by rote in 1/2 hour and repeat them in 5 minutes." So it is nothing but rationality and common sense. On chapter 4 of this book, under the title, The Law of Criminal Evidence, the author brings out that the assigned trials which were taking place in England, which resulted in judgments which ultimately were used as the basic material by authors to write the law of evidence, brings out that there were 2 principal rules relating to evidence, and there were 2 subsidiary. The 2 principal were the character rule, which related to the credit of the witness. And since I'm addressing an audience of judges, you will always find that there are only 2 elements when we appreciate the testimony of a witness. The first is whether the witness has been discredited, and the second is whether his testimony has been discredited. See, those rules were framed way and back. The first was the character rule, and the other was the corroboration rule. The rule of corroboration is not what we really see today in its form. What it said was that in the making of the statements by witnesses, are they being corroborated by the principles of logic and reason? If they were, the witnesses had to be believed. So the appreciation of evidence turns once again only on two principles: the credit of the witness, the credit of the testimony of the witness. The two subsidiary rules which emerged were the confession rules and the hearsay rules. Now look at the beauty of the confession rule. It's not the confession rule which we talk of in criminal trials. It talks of the matured rule excluding evidence of confession forced from the mind by the flattery of hope or by the torture of fear. See what we are seeing: an entire embodiment of section 18 to section 27 of the Indian Evidence Act. It is in this historical perspective that we look at the Evidence Act. We find that from section 6 to section 36, we have guiding principles of collating what would be relevant evidence for a court to decide a fact in dispute. So whether it is preparation, whether it is conduct, whether it is evidence post-contract, whether it is evidence of how the parties behave during the contract at a civil trial, in a criminal trial, it could relate to charges of conspiracy, etc. So those are the provisions. But even if they were not to be there, common sense and logic says, as Bentham said, any fact which has the tendency of affirming a fact in issue or repelling a fact in issue becomes a relevant fact. Now let's understand by a general illustration, because general illustrations, I believe, are extremely helpful to pick up from a commonsensical point of view the core of an area of law. Now, when we say to appreciate evidence, what does it mean? Appreciate for what purpose? To appreciate the evidence for the purpose of returning a verdict, whether a claim has been sustained or a claim has not been sustained at a criminal trial, whether a charge has been sustained or a charge has not been sustained. Now, what the judge gets at the end of the trial is a mass of material. It would be documentary evidence at the criminal trial in the forms of first information reports, the police investigation reports, the forensic reports, the recovery memos, the identification memos, and so on and so forth. At a civil trial, it would be, apart from the ocular evidence, large volumes of documentary evidence. So this mass of evidence, when presented to the trier of the fact, would require the trier of the fact to determine whether a fact in issue, with reference to relevant facts which have a bearing on the fact in issue, tend to probabilize the assertion, or it doesn't tend to probabilize the assertion. It's easy said, but how do you apply it? Now, let me give an example of a cauliflower potato dish. If I was to make a cauliflower potato dish and serve a helping to all the viewers and ask them to rate it on a scale of 10 with informing that to get good, it should be 6. If it gets less than 6 points, then it would be bad. How would you do? Well, a normal man would tend to say, would jump at the gun, well, I'll taste it and I'll rate it. But is that so? There'll be a huge utter problem. Some people like spicy food, some like bland food. Somebody would prefer their cauliflowers and potatoes to be blanched and just diced. Somebody may like the potatoes to be well fried. Somebody may like them to be cooked well in oil, and you would have utter confusion. The recipient of the verdict of this gathering would be thoroughly confused. Half of them would be saying it is excellent, and half of them saying it is horrible. But what would a good trier of this problematic problem which I have given eat the cauliflower potato dish and rate it do? He would say things that, look, I have to decide facts, and fact is something which I can perceive from my senses. So this is a potato cauliflower dish. How do I perceive it? I perceive it from my eyes. I perceive it from my olfactory senses. I perceive it from my taste. So he would say, I'm going to use 3 skills which I possess: eyes, nose, and taste. Having done that, what would he do? He would say, I have to rate it on a scale of 10. So I have 3 senses to perceive it. So I must weigh my 3 senses and determine what weightage do I have to give to a particular sense, which would then give an attribute to the evidence which I'm having before me. So he would say, well, man has developed aesthetic senses, so I'm going to give some marks for the way this dish is presented. This is exactly what we do when we are given with evidence. What weight do we give to a particular piece of evidence? At the end of a trial, civil or criminal, no judge says, I have listed positive evidence led by the plaintiff, positive evidence led by the defendant. The plaintiff has 7 elements of positive evidence, the defendant has 6, so 7 is to 6, the plaintiff wins. It's not a boxing round at all. He says the 7 relevant facts which the plaintiff have proved are weak in its weight. The 6 which the defendant has proved are heavy in its weight. So similarly, in this potato cauliflower dish, you would then say that I have to rate it on a scale of 10. So let me give some mark for aesthetics, presentation, and all of you would agree between 3 to 4 marks you would give on how the dish is presented. Then you would say aroma. What is the flavor which I am getting through my olfactory senses? So on the aroma, you would say 3 to 4 marks. But if you're given 4 marks on the other 2, on taste you would be left with 2. And you say, no, taste I think is more important than the aroma. So let me scale down my aroma from 4 to 3 and get my taste to 3. And you say, well, presentation 4 is also not good. So 3 to presentation, 3 to aroma, and 4 to the taste. Now, what you would find is that there would be a greater homogeneity in the decision-making process. But we have a problem. If somebody adds on, are you rating this potato cauliflower dish as one which you eat in your house as nutritional food? Oh, I forgot. You eat food for its nutritional value. So my 3, 3 and 4 are all gone for a toss. I have to determine the main purpose of food being nutritional value. So I'm going to give 5 marks for nutrition, which would be determined that it is not overcooked and it's not hard on the stomach. It is not undercooked as well. And then you'll be left with 5 marks. So you would say 1.5 mark to presentation, 1.5 mark to aroma, 2 marks to taste, because ultimately you are eating it as a part of your meal. The point which I'm trying to bring out is that the task of appreciation of evidence has 2 limbs. The first limb of identifying what is a relevant fact is an easy task because common sense would guide you that what is a relevant fact. But the second part of it, weightage, and that is where we will find that if you would look at your Bible, the law of evidence, it has 3 chapters. The first chapter, which is from section 1 to 55, talks of the relevancy of facts. So if you have to determine whether a fact is relevant or not, you look at first part and come to an end at section 55. The second part is on proof. So if you have, the fight is whether a document is proved, whether a fact is proved or not, you look at section 55 to section 100, and the trouble lies when we cross over to the third part of the law of evidence, which starts from section 101 under the caption production and effect. So the example which I have given, it is at the stage of production and its effect that we land up with issues. The issues would be that for a judge, it becomes extremely important. And when I say a judge, I mean a trier of every fact. It becomes extremely important to determine what weightage has to be given to a particular fact, what weightage has to be given to another particular fact, what weightage has to be given to another particular fact, and then determine whether on the weighted average of these facts, the rule of preponderance of probability at a civil trial and proof beyond reasonable doubt at a criminal trial has been achieved. Well, you'll say, well, I've identified my criteria. It is food, which I have to evaluate on a scale of 10. It's a potato cauliflower dish, 5 marks for nutrition and 5 marks for the other 3. But there's a problem. Let's change the circumstance. Now, this is a circumstance of a cauliflower potato dish to be ascertained and marks given as you eat it in your house with your mother or your wife or your cook, or you yourself cook it or eating. But if you go to a 5-star, what would you do? The circumstances change. Well, it's doubtful whether we would go to a 5-star to eat nutritional food as the primary object, or the primary object of going to a 5-star is to enjoy the ambience, of course eat good food, and the manner in which it is served. Yesterday I was talking to somebody that at lockdown 4, they said, well, the restaurants are open. And somebody told me that, well, Taj and Hyatt, the kitchens were open. But yet people were not buying food from there. Why? Well, you wouldn't pay 5,000 rupees for a meal for Taj to pack the meals and you serve yourself and eat it. You would better sit at the restaurant, the Taj, to enjoy the ambience and somebody serving the meal for you. You pay for it. So when the circumstance in Bombay, the fact has changed, the entire criteria has changed. Now probably you won't give 5 marks for nutrition. You will give a lot of marks for the way the food is presented. You will give more marks for aroma. So you will land up with aroma and presentation now being weighted up from 1.5 and 1.5 weighted points to maybe 3 and 3, nutrition 2 and the other 2. Now let's change the circumstance. This potato cauliflower dish has to be served to a patient who has undergone a liver transplant surgery, and after 3 weeks he's getting something to eat. His entire digestive system had to be put to rest. So for 3 weeks after the surgery, the poor fellow was getting the diet through the intravenous glucose bottles. So after 3 weeks, he's getting the cauliflower potato dish. You think this guy would be in the framework of mind to be bothered about the aroma? I'm sure over 3 weeks with so much of injections and medicines, nothing would be left in his olfactory senses to get the aroma. So you give aroma 0. Do you think there would be something left in his taste buds with so much of medication? Nothing. So taste, nil. Maybe a little bit on presentation. If it is well presented, he may be little keen, but 1 mark. You knowing fully well that he's going to eat on a system which has been rested for so long, he would hardly have an appetite. So you would like to ensure that the cauliflower potato dish which is being served to him is extremely, extremely rich in its nutrients. So what do we find in such a case? Nutritional value 9 marks, aroma and taste 0 marks, and presentation maybe 1. So see how when circumstances in booming, the facts change, the very criteria, the very basis and fundamentals of your appreciation of evidence changes. It is in this manner that the same thing happens at trials. Now let us take an illustration. At a trial where A has sued B for recovery of money, and the loan was given at a time when they were friendly, and we know that in India we are most unofficious when it comes to dealing with friends. And the only evidence which comes forth is the evidence of C, who says that at a particular day, when B had asked him for money in the presence of D, D had said, don't give money to B because he doesn't repay the borrowings which he indulges in. He has not repaid A, and B did not refute this statement and walked away. If this is the only evidence, it is not direct evidence of a loan, but it is a very strong evidence of a conduct. What conduct? B had asked money and an intervener had told the person, don't give money to B because money has not returned the debt of A. And B, who had a duty to speak and rebut, did not do so. It would be an acceptance of the assertion by estoppel and conduct. Nonetheless, I would be failing if I don't guide the learned judicial officers that, broadly speaking, at criminal trials, while adverting to the appreciation of evidence and the weightage to be given, we need to look at 12 factors. You have to look at your FIR timing, to look at the close proximity of the time to the information. And the logic of this is it gives lesser time for a witness to concoct, and statements made contemporaneous with an event are presumed on a logic to be more powerful because it gives less time for a person to be tutored. The second area to be looked at is, let me list them out. So one is FIR, two is hostile witness, third is inimical witness, fourth is interested or partisan witnesses, next is non-examination of independent witnesses, next is solitary witness, whether he happens to be a chance witness or is he a planted witness, testimony of extrajudicial confessions, inquest reports, statements under 161 and 164 CRPC, tying declarations, and test identification proceedings. So these are the 11 circumstances or the nature of character of the evidence which comes before a judge at a criminal trial. I don't really intend to get into the nitty-gritties because the time doesn't permit, but keep in view the two guiding principles which I had spoken of when I looked at this book. The two guiding principles is the credit of the witness and the credit of the testimony of the witness. Please put the two types of evidence in the two compartments, and as with the example of the cauliflower potato dish which I gave you, packaging needs to be done. See, we do it every day in our lives. Mr. Singh is today wearing a saffron turban. He didn't wear it randomly. When he got up in the morning, he must have said, oh, yesterday I wore a pink one. The other day I wore a blue one. The other day I wore a gray one. Let me wear today a saffron one. All of you would have taken different food at the breakfast. Somebody just had fruits and milk. Somebody may have had a fried paratha. Somebody may have had fried eggs. Somebody may have had boiled eggs. Was it random? No. All of us decide, oh, last night I was at my friend's place for a dinner and there was a lot of tasty non-vegetarian food. The fellow had made chicken, he had made mutton, he had made fish, and they were lovely prawns. And what excellent drinks. So from 2 pegs, I was up 3 pegs, and I took a lot of prawns. I'm feeling very heavy. So today morning, I'm just going to eat fruit and even skip my milk. The other fellow says, oh, I had a very frugal dinner last night. Let me have a heavy breakfast. Double egg omelette, bacon and ham, 2 good potatoes, polished up with a lot of cold milk. Every human takes at least 15 to 20 decisions personal to him in a day, but we don't realize it. Should I get out of my bed or should I laze around for 5 minutes more? That's a decision. Do I brush my teeth right now or do I just gargle and open my window and then go back to brush my teeth? That's also a decision. Do I take my bedsheet sitting next to the window in my bedroom? Do I go out to my balcony? Do I sit on the dining room and have it? That's also a decision. I have to attend a webinar at 11. Do I take my bath at 10 or can I wait till 10:30? Do I wear this jacket? Do I not wear this jacket? What is my backdrop? It determines. So we see that the human mind is trained, but the only difference is decisions which are personal to you, which only affect you, may only be commented upon you by, oh, the fellow is ill dressed. Somebody sees you eating a lot in the morning saying he's a glut, but it doesn't affect society. But decisions which you take as a trier of fact affect society, and therefore you have to train yourself. And what you have to really train yourself is very, very simple. As Mr. Buke said, his parrot can parrot it in 5 minutes. You would be laughing that if the parrot could say it in 5 minutes, why is this ex-Chief Justice taking over an hour? Is he worse than a parrot? We would be better off if the parrot was there to tell us. So I would just bring it down. There are 2 fundamental guiding stars. It is simple. A logical mind moving in the direction with respect to keeping into account the parameters enwombing within the circumstances. Please do not forget, it is the circumstances which are enwombing, packaging your facts, and then determining what weight to be given. And once you've done it, there would be no problem. And I think with this, given the time and given what the span of this field of appreciation of evidence is, I would like to thank and quit and wait for some questions to come.
Sir, thank you so much. Mr. Yelagada sir would take the questions and he will formulate the questions for you and you'll ask it over here itself.
Please.
Sir, please.
Thank you, Chetan. Thanks, my lord. One question is that the witness whose affidavit has been filed on record dies before his cross-examination. He died before his cross-examination. Only affidavit was filed. Question is how his evidence is to be appreciated?
We have only one judgment on the point. I'm forgetting its citation, but I remember it was authored by the legendary Justice Hansraj Khanna, H.R. Khanna, in which at a criminal trial, a witness had deposed, and before he could be cross-examined, the witness died. And the court was confronted whether the testimony of the witness in examination in chief has to be thrown lock, stock, and barrel, or could it be used? So the court reasoned that cross-examination is a very powerful tool in the hand of the opposite party to get ascertain the truthfulness of the statements made by the witness. So therefore, if a witness has not been cross-examined and he dies, the opposite party has lost a valuable right. So factor that in mind. But at the same time, the court said that at a trial, the task of the judge is to find that elusive nugget of truth. So the court said, blended the two rival claims and said that the evidence can be read, the testimony of the witness can be read in evidence, but limited for purposes of corroboration. It can be used to corroborate other evidence and cannot form the basis of a judgment by itself, standing on its standalone weight.
Sir, if it is in a civil case, only affidavit of examination in chief is filed, but the witness was not available for cross-examination.
Now, let's understand. It is that was the case where the witness died.
Sir.
It is the duty of a party to produce the witness for cross-examination. If the witness is alive and the party is not able to bring the witness, then the testimony of that witness has to be ignored, because that judgment talked about a situation akin to a force majeure. What do you do if a witness has died? Yes?
Sir, I may be wrong, but what the practice is that it is evidence as if his examination in chief is done. When we take evidence of affidavit as if it is examination in chief, but
right.
If that witness is not available because of death, that party other side did not get the opportunity. Therefore,
so Mr. Aldana, I think answered it correctly.
Yes, sir. Yes, sir.
If the witness dies, it is different.
Yes, sir.
But if the witness has not died, it is different.
Yes, sir.
So if the witness is dead, whether it's a civil trial or a criminal trial,
Sir.
It would not matter. But keep into account one fact, that the other side has been denied the opportunity to cross-examine the witness. Now you see, as I said, Mr. Yalda, it's a matter of common sense. If that witness has only proved a particular document, now what cross-examination could be warranted? The judge has to be cognizant of the fact. Now let me give an illustration. The witness is to the proof of a MOU being drawn up and signed.
Yes.
This witness says that we had prior negotiations which the other side agrees. They had discussed the commercial terms and the contractual terms in emails, which is an agreed fact. But the other side says that, look, we were always at loggerheads on the price. Look, all our emails show we were at loggerheads on the price. So when we sat down with the draft of the agreement, the dispute was on the price. And ultimately, we could not agree on the price. This witness has deposed to a draft initialed containing the price. You forget about the witness having died. Now let us take the case where the witness or the other side admits that the meeting ended at 6 in the night, 6 p.m. in the evening. Situation 2 where they said, well, they were so desperate to firm up on something, it went on till 12. And now the dispute is that till 12 midnight it went, could they or could they not? Now, in the first case, the opposite party knows that this witness loves alcohol. He asks, do you love alcohol? He said, yes. He says, if you find good alcohol, where do you stop? He said, well, if I get good alcohol, it just depends on the ambience. I don't know whether I stop or not. I only drink one because after I take one, I become a changed person. So the changed person takes the other one. Now, this line of cross-examination would be most irrelevant if the parties are agreeing that the meeting was over at 6. Because the normal course of human conduct is, people enjoy their drinks after they've done their hard day's work. Nobody starts drinking at 5 o'clock and gets drunk by 6. But if it is a case where the document, he's proving that the document, and he asserts it was signed at 12 in the night, then that line of cross-examination, which you also have issues that how much of cross-examination to be allowed. Now, if it is proved the guy had 6 pegs down starting, and the dinner started at 9 and went on till 10:30, and then they sat down again, this witness would be a discredited witness to establish it. Now, let's take this. This witness is dead. Now, it is so crucial to cross-examine this witness, to ascertain. So ultimately, these are not theoretical questions to be answered in theory, because life is not theory. As they said, that the logic is practicality. So depending on the situation and what kind of other evidence you have, so you would use this evidence as a corroborative piece of evidence.
Thank you, my lord. Now, next question is relating to the POCSO Act offences. Whether a minor victim girl who is declared as hostile, just a minute. Who is declared as hostile as she did not support her 164 CRPC statement, can be prosecuted for perjury.
As you said, the victim is a minor.
Yes, sir.
So probably, I presume she would not be deposing on oath.
Yes, sir.
So if she's not deposing on oath, then where is the question of prosecuting her for perjury?
Sir.
And Mr. Alana, let us take the case where the victim is not a minor.
Sir.
You would have come across cases, and I've come across cases.
Love matters.
Yes.
Love matters. Yes, sir.
Yes. Not only love matters, cases where the trial is so delayed, the lady is married. And she says, I can't now come to the witness box and admit to the fact that I was raped when I was 16 years old. So you see, judges have to be. Now, when we talk of perjury, is the person perjuring out of sheer helplessness? Or is the perjury ill-motivated? Ill-motivated. So as we said, you see, I always said, Bombay High Court is a unique and a great court because that's the only court which has at its entrance the statue of Justice Justitia, and on the other side is the statue of Mercy. So if you don't blend your mercy, and ultimately, what are we doing? We're doing justice. I hope I've answered your question.
Yes, my lord. Yes, my lord. Thank you, my lord. It is again relating to a similar question. How to appreciate evidence of a witness who supports prosecution in examination in chief, but in cross-examination takes complete U-turn, but the prosecutor did not take efforts to declare hostile and later on cross-examine. How to appreciate the evidence of such a witness?
You see, if you would see a hostile witness, we have that celebrated judgment of the Supreme Court. Now, I can't really take the citation, but it's in Fundi's case, Fandi, Fundi's case. It was relating to Fandi versus state of Madhya Pradesh, or maybe it's state of Madhya Pradesh versus Fandi, where the court said that a witness who has supported the case of the prosecution in his examination in chief and has turned hostile in cross-examination and has not been declared hostile and re-examined by the prosecution. And that's a big problem we see. The prosecutors don't bother about these things, but the court said this witness's testimony would be akin to the testimony of a witness who partially tells the truth and partially tells the lies. And the courts have said that for such witnesses, such part of their testimony which can be used for corroborating, or such part of their testimony which is corroborated by independent evidence, that can be used. Now, for example, the witness in his examination in chief says that he was at the bus stop of the village at 11. 4 people came. 4 were armed. 1 had a gandasa, 1 had a sickle, and 2 had dandas. They assaulted the victim, who ultimately died. In examination in the chief, he says A was carrying this, B was carrying this, C was carrying this, and D was carrying this, the 4 accused. But in cross-examination, he says, I don't know whether A actually was there. I am doubtful whether A was carrying the gandasa and all. Now, the courts have said that there were 4 assailants. He has not contradicted himself. That the 4 assailants were armed with 4 weapons comprising 2 dandas, 1 sickle, and 1 jelly is not. So he has turned hostile by assigning roles, but doesn't matter. At least his testimony, there were 4 people. All 4 were armed. Each one of them was carrying 1. At least this is established. Now, when you would then find something to corroborate, and here when we find where is the corroboration, inquest reports can be very important. And that is where a good investigating officer, because he's got the statement of this witness as the statement recorded, so he exactly knows. Why should he not ask the doctor how many injuries are there and ask the opinion? How many are blunt object injuries? How many are sharp object injuries? How many are curved injuries? Unfortunately, Mr. Yadav, what has started happening today is the trials start failing at the stage of investigation. If you read the form of the inquest papers under 172, the IO is supposed to seek the opinion of the doctor on the nature of injuries, and if he's already got the weapons with him, he's supposed to ask that. We don't ask that question, but Fundi's judgment is the basic judgment.
Thanks, my lord. My lord, your honor has referred to the value of the FIR, which was immediately lodged. The question pertains to how to appreciate the evidence of a witness summoned under section 311 of the CRPC, obviously whose statement under section 161 or 164 of the CRPC was not recorded. How to appreciate such a witness evidence?
Well, you see, let us put like this. Again, as said, go by commonsensical principles. A first information report is a statement under 154 CRPC and has a greater evidentiary value vis-a-vis a 161 statement, which in law can only be used to contradict and confront a witness. But don't forget, I can take out hundreds of judgments of the high courts and Supreme Courts where the courts have said this witness inspires confidence because what he deposed in court, he had told the investigating officer 2 hours after the crime. We use this for the creditworthiness of the witness and not the creditworthiness of the testimony of the witness. Once we keep this in mind. So back to your question. So whether it is a 161 or a 154 statement, if the witnesses are standing by their 161, if they are standing by their 154 statements, well, the accused has a problem. But the problem is when they turn hostile. Unfortunately, what has started happening is the prosecutor just wants to get rid of the trial. He said the witness has turned hostile. What can I do? He just puts the suggestion. I put it to you, you said this. I put it to you, you said this. I put it to you, you said this. I put it. He doesn't really cross-examine the witness. Now if the witness says, well, I wasn't there. I never saw anything. I never seen a cross-examination. That look here. Did you ever meet this gentleman who's standing as in the police dress? I would say, yes, of course. When did you meet him? Yeah, this guy came to me. Why did he come to you? Because somebody told him that I know something about the crime, but that was wrong. Okay, no problems. So when he came to you, what did he do? No, I don't remember. But you remember that he was writing something? I think he was writing something on that. How long did he interact with you? Oh, for so long. Where do you live? I live here. Where's your shop? It's here. Is the market square next to your shop? Yes. Do quarrels take place there? Yes. Have you ever seen that, Mr. Yadlada? Yeah. Yeah. So no point to talk in the air.
Sir.
No point to talk in the air. The
Sir.
thing is very simple. If you have to, again, I said you made your dish very well. But the good chef always doesn't say how much salt. He always says salt to taste. He'll tell you the exact ingredients, but he'll say salt to taste. So if there is no salt to taste, worthless.
Sir, this is a question pertaining to the book Origins of Adversary Criminal Trial. Page number 331.
331.
Page number 31. 331, sir.
331.
Yes, sir.
Yes.
Question is.
We have the same edition. Yes.
Sir. Question is, don't you think that this book actually criticizes the way adversary trial approaches the criminal case? It means it makes truth seeking at trial a byproduct to the rules of evidence, which is a major fault in system.
Well, if you have read this book properly, you would find that at what stage were lawyers permitted to enter criminal trial at their assigned courts. And if I may read out from page 16, it talks of the rapidity of the trial. So rapid were the trials, it says, the altercation trial was an abrupt affair. At provincial assigned courts in the Elizabethan Jacobean period, 1558-1625, the average duration of a trial included time for jury deliberation had been reckoned at between 15 to 20 minutes. There were cases of felony which resulted in death sentences. There were cases of assault, so on and so forth. Then what happened, if I may read at page 18, The conveyor belt at the Old Bailey ran so monotonously that on one occasion a trial went its course before anybody realized that the court had just tried the wrong man. One John Smith was indicted and tried for stealing 9 pounds of raisins. Put to his defense, after the prosecution evidence, Smith replied, "I'm not the person. I know nothing of the matter. I was committed upon suspicion of forgery." The astonished prosecutor, looking at the prisoner, acknowledged that the man at the bar is not the person they intended to try. So at that stage, they said, the accused must be given the right of a lawyer and the lawyer to have the right to cross-examine. But as I pointed out, this book brings out two things. The combat effect at the trials is that it becomes a duel between the lawyers, and the lawyer at the cross-examination took away the trial from the hands of the judge. Yes?
So
yes,
thank you.
There would be a problem. So what you read at page 331 has to be read in light of
16.
what we have read on page 18. And surely you would not like people to be put on a treadmill going for trial and 15 minutes. You are right. There is a view, if you read Malimat Committee's reports, that should you have inquisitorial trials? Would inquisitorial trials be better than this? But it's a matter of debate. It's for the society to determine. The rule of a judge is, after all, we have to decide as per rules which have been made by the society. So we have to go by that.
Thanks, my lord. In academy also, my lord, you might have observed, we also observed that when we give a similar paper book to a group of 50 judges, they write differently. In that context, the question is, what should be done to reduce the divergent ways of appreciation among the judges on the same sort of evidence?
Yes, you see, as I would say, the problem lies that witnesses come random. A witness, say, has deposed to, if you see section 5 says evidence would be led of a fact in issue and such other evidence which is hereinafter made relevant. So such other evidence which is made hereinafter relevant would be evidence from section 6 to section 36 going into expert testimony. Now, let us take if there is one witness on the plaintiff side which talks of the execution of a document. Let's take a will. He is a direct evidence. Now we have witnesses of, say, conduct. Conduct of the kind that the executor of the will was in litigation with a son whom he has disinherited. So this would be an evidence of a witness who would say that, look, I brought the record of such and such suit. The plaintiff is so and so. He sued his father on the plea that this property is ancestral and he lost the suit. This is a suit instituted by the father to evict him from the house. So this would be evidence of motive. Then somebody says, this man lives in my neighborhood. He was my evening walker friend. He was most disgruntled with this son, but would always tell me that my grandchildren are good. So I don't want to deprive them of their inheritance. I want to disinherit this fellow. Now, the task of the judges, and that's where it is, direct evidence is weighty evidence. It is strong evidence. So if the witness to the execution of the will has stood, the other evidence becomes weak. Well, he wanted to give it to his grandsons, but at the same time he wanted to deprive his son what ultimately led him to execute the will, excluding one branch fully or not. Now the question, as I was saying, is judges, if they package their evidence, they would, if they write, this is my direct percipient evidence, these witnesses have deposed to pre-execution contact, this witness has deposed to the post-execution contact, this witness has deposed to prior statements made. So if you package it, then there would be greater consistency. And at the Judicial Academy, what you really need to teach is how to, that would fall in an entirely different domain, the art of judgment writing. And that also, when I spoke, I used to always give an example that if you go to a tailor and give a cloth, he doesn't start cutting it at random. And if he has to make a shirt, what does he do? He understands that he would need one very large piece, which would be the back. He would then need two halves of what is at the back for the two front. Then he would need two for the sleeves. And then he would need a small one for the collar. He would need one for the collar. And then he cuts it. And not only he does that, he also looks at the nature of the fabric. Is it having stripes? Is it having squares? Or is it having a self-design? So he accordingly puts the collar. You never see, he designs it properly. He'll put the collar where the stripes are going along the collar and not going vertically down. And when he puts the pocket, he ensures that the pocket is having stripes which are stitched in a manner which go along with the fabric of that. This is exactly what you have to do with the judges. Now, what I find is this packaging needs to be just taught. And if they do, there would be consistency. Keep the cauliflower potato dish in mind. It would act as your Bible. Identify your criteria, look at your circumstances, and then say, this is my weightage, this is the production and effect, and that's my judgment.
Sir, one question is, in a rape case, the victim, that is the informant, denies on oath that the accused had sexual intercourse with her, but the medical evidence, serological test showed that there was intercourse. How to appreciate that evidence?
Well, it's like this. Two things. Did a crime take place? Who is the author of the crime? Keep that in mind. Don't mix and merge the two. Now, if sexual intercourse has taken place, it only proves that the lady was subjected to sex. It could be sex by consent. It could be sex against her consent. Let's understand that. So structure your judgment. So the MLC has only proved that she was subjected to sex and no more. If the MLC also has signs of violent struggle and the place where the crime has taken place is a field and evidence has come there, look at your Bible. The problem is that most of us don't read our Bible. And if you have to sing a psalm, which people say is a hymn, you have to sing it as it is contained in the Bible and no other way. People have a lot of confusion when they talk of hearsay evidence, but we forget that there is an illustration J under section 8 And if I may read that illustration J under section 8, it says is, the question is whether A was ravished. By whom it is not. The question is whether A was ravished. Exactly what you put. The fact that shortly after the alleged rape, she made a complaint relating to the crime, the circumstance under which and the terms in which the complaint was made are relevant. So, the circumstance under which, now let me give you an illustration. I authored a judgment in the Delhi High Court where there was an evidence that this domestic help had a sexual intercourse with the maid of the adjoining flat, the building complex I need not tell. It was next to a police station. She made a complaint to the police at 11 that this fellow who was the domestic help in the adjoining house, on finding that after she had swept the floors of the flat opposite to where he used to work, she had opened the door with the broom and the entire dust which she had collected from the floor and was picking it up in the pan. This fellow pushed her inside. There was a toilet just next to the door, and he subjected her to forcible sex. She said that, and in fact, not only is a case she didn't retract, but she stood by that, even in the court. But in cross-examination, she admitted to the fact that after cleaning the house, as she went down the lift, she was seen by her brother in the company of this man in the lift. And the issue arose that did her brother sense out that these two people had indulged in some mischief? So the circumstance in booming her allegation becomes extremely, extremely relevant. There's another case I did where this girl was gang raped. She told all lies. Now see what had happened. The case of the prosecution was, as per her statement, that this fellow was just barely known to her. She had left her house to buy a copy. He saw her, he said, I'm in my car, it's summer months. I'll take you to the market and get the car. And she said, when I sat in the car, I said, the other people were there and they took me, they drove me all over. Then she said, first they took me to this farm. The fellow in the farm said, oh, you come with a girl. I know you want to do something hanky-panky. I won't let you in. Then they went here, then they went here, then they went here. And then they said they raped me in the car. There was telltale evidence that on the mobile phone, she had been speaking to the guy. There was telltale evidence that that day in the morning, she had called up this guy 10 times. There was evidence that she had rung him up at 2:30 when her parents went to sleep in the house during summer months, and she left the house. Now the problem was her love was cheated. This guy had got a friend, he said, oh, there's the girl is with us. So all they did was they loitered around in the car till it became 7, it became dark. And that was the time when they subjected her to rape. So it was very easy for a judge to say she had to hide her shame. She had to hide the truth from her parents. She had to show that she was not a consenting party, but consenting to what? To only move around with this guy. So the first part of her story was all fabricated because it was her compulsion to fabricate. Remove that chaff, the remainder is the grain. Now what happened when it became dark? The guy said, now you got the opportunity, and rest, she was totally corroborated. So as I said, the circumstance under which events have taken place throw a lot of light, and if you keep those in mind, you have no issues.
Sir, only two questions because I'm taking them, they are most common. One is how to appreciate the statements of accused under section 313 or maybe while recording the plea under section 251 of the CRPC.
You see, under 313, let's be very clear, there's a lot of confusion which has unfortunately emanated out of some judgments of the Supreme Court, where they said that false answers can be used as a link. Now let's understand what is 313. A 313 is to give an opportunity to an accused to explain the incriminating circumstances which are emerging from the evidence. If he can explain the incriminating circumstances from the evidence, and if he's explained it and if the explanation is plausible and it has not to be fantastical, the accused is entitled to be acquitted. But if he simply denies, and at a stage where the prosecution has led evidence to prove and discharge its burden, and the stage of section 106 of the Evidence Act is reached, only in then circumstances, only in that case, a denial or a false answer can be taken as an extra link. Again, we have a very beautiful judgment of the Supreme Court in AIR 1971. Page number I'm forgetting. It's again a judgment authored by Justice H.R. Khanna. If you will just go to the Supreme Court judgments of 1971, you just go to Criminal Trials 302, Justice H.R. Khanna, and you'll get the judgment. Now see, what was the evidence against this accused? The evidence against this accused was witnesses deposed that he was carrying on business as a shopkeeper at a shop which was 1 kilometer away from the house. And there were two crossings on the way. It was proved. It was also proved that on the day when his wife was murdered in the house, he had left for his shop. It was also established that after that he came back to his house. It was also established that he was seen running away from his house at around lunchtime with his hands smeared in blood and his clothes smeared with blood. It was proved. What did he say in 313? In 313 he said, look, I'm a shopkeeper. On that day I left for my shop. When I reached the shop, I suddenly remembered that I had told Mr. Kalluram to come and collect money, which I owed him. The money was in my house. I had given it to my wife. So I left my shop to go back to the house to pick up money. And then he says, when I reached the house, I knocked at the door didn't open. So I thought my wife is taking a bath. And at this stage, when I was waiting and pacing up and down in the veranda in my house, this fellow must have seen me. When the door wasn't open, I said, well, that's strange. My wife would normally take a bath in about 10-15 minutes. So I went at the rear. I saw the window broken. Curiosity, instinctively, I realized something is wrong. Somebody is broken into the house. I went inside from the window and I saw that my wife was lying on the floor, smeared in blood. Instinctively, I picked her up. Maybe she was alive, I could comfort her. She was dead. At that stage, my hands got smeared with blood. Blood came onto my clothes. I opened the door and I ran to the thana. Of course, I crossed the chowk. This guy must have seen me. When I went there, the duty officer, I told him that this has happened. He said, you're telling a lie. You murdered your wife. Now you're acting smart. And therefore, we are not going to record this. We're going to record a confession that you said, I came house to get the money. My wife refused to give the money and in anger I hit her. The judge said, he has explained everything in 313. The explanation is reasonable and probable. Why? because the circumstances involving this medicine, this evidence was sans a motive. The court said there is no motive. Why would he do that? So this is when we talk of 313. So it's an opportunity to the accused to explain, but unfortunately, you know what we find in India? Denied. That he died, denied. The post-mortem, denied. Abroad, you know what he says? Well, this relates for my lawyer to argue. We in India don't do that. But yes, it's a golden stage, whether it's 251 or whether it's a case of 313. If an accused can explain the circumstances, the judge has to factor that in.
My lord, one more question, last question. Multiple dying declarations. How to appreciate multiple dying declarations contradicting each other?
Yes.
In the question, it is mentioned 3 dying declarations, maybe 2 or maybe 3, 4. Yes.
I have dealt with a case of five dying declarations.
5.
I have dealt with where there were 5 dying declarations. Now, law says that if there is no corroborative evidence, then a conviction can be rested on a dying declaration, provided it inspires the judicial conscience of the truthfulness of the dying declaration. So starting with this premise, and that is why I said judgment writing should also be premise. The judge should write. It is settled law that a dying declaration which is not corroborated, if it inspires confidence, it can be taken into account.
Sir.
One second.
Sir.
We're running short of time?
No, sir. You can have some time. No problem.
2 minutes.
Yes.
The first dying statements made spontaneously by their very circumstance of spontaneity are entitled to a weightage. Let's take in that first dying declaration, which she has made to a neighbor, that the woman has been set on fire. And to the neighbor, she says that, look, I accidentally caught fire while heating milk for my child. Well, she says that, no issues. She's reached the hospital, she's in pain. She tells the doctor, she repeats the same thing to the doctor. Then on the 3rd day, she realizes that she's suffering from septicemia. She realizes that the bilateral clefts have kept in. She realizes that probably life is ebbing. She tells the doctor, please call the investigating officer. And she says to the investigating officer, look here, my first 2 statements were made because I believed I would survive. I have 2 daughters, and the only way for my daughters to be brought up and groomed is the income of my husband. I had them in mind. I had my matrimonial bond in mind. I told lies. The truth is that this fellow, for such and such reason, assaulted me. He was an alcoholic. He wanted more money for alcohol. I didn't have. Now, the proximate dying declarations have been supported as a cause of death as accidental by her. But if the IO finds when he entered the kitchen, there was no pan. There was no milk in the pan. He finds no evidence of the gas being lit. He finds that the matchbox which was kept at the top was there at the top. He finds no evidence of the first 2 dying declarations that my child got up at night and I was heating milk is disproven. Yes, the third dying declaration can be looked at. Because this is now being corroborated. So law says, number 2, that if you have multiple dying declarations, look for corroboration. Which dying declaration is? Because in Indian circumstances, that's why the courts have said, her first dying declaration was made when the neighbor was there, the husband was there, the father-in-law was there. How could she have said this guy has done it? But then at the hospital, her parents came, her mother came. Right? Tutoring can also take place. But if there is evidence of dowry demand and harassment, so ultimately, Mr. Yadwada, it all boils down to that basic thing. Look at the circumstances involving the evidence. The circumstances tell you a lot. It's a matter of hard work, sieving every fact. And I always give this example. The witness says, I was standing at the square, I saw a deep red colored car driven rashly and negligently hitting the pedestrian. How many statements are there? Keep into mind that I was there. Why? It says it's a relationship of thing to a place. So this statement has how many facts? Fact number 1, at 11 o'clock he was there. Next, he saw 2 cars. Next, 1 car was red. Keep into account this deep red could be a matter of opinion. So you must say it was a red colored car. The cars collided. These are facts. This deep red is a matter of his opinion. That the car was being driven fast is a matter of opinion. So please keep into account this one statement has 4 facts and it has got 2 opinions. If we can start understanding it in this manner, and if judges can, it is very, very easy. Unfortunately, what has started happening is, before we discuss the facts, the judgment would be in such and such judgment, the Honorable Supreme Court held this, the Supreme Court held this, and this, all cut, paste. And you say, well, that's damn good. But where is my recording of facts? It's not there. If it comes, Mr. Yalada, I have no doubts. There should be no problems.
My lord, one more question, which is a very day-to-day challenge to the criminal court judges. We are aware that in most of the criminal cases, there will be recovery, seizure of a thing, maybe a stolen article, stolen property, or a weapon of offense. And it may be coupled with or may not be coupled with a discovery statement. Nowadays, it is common that in many of the cases, the punch witnesses are turning hostile. In such situation, I have also observed that especially the new judges observing that, starting with whether this panchanama is proved or not starting with the statement whether the discovery statement, the statement by the accused was proved or not, and whether this consequent seizure was proved or not, instead of discussing like that. So the viewer's question is, when the punch witness turns hostile, with the help of the investigating officer's evidence, and sometimes with the help of the complainant's evidence regarding the identification of that property as the stolen property, how to appreciate that evidence?
Let's put it like this. If the discovery statement itself is not proved, it is discovery pursuant to a disclosure statement, which assumes incriminating character. So if the disclosure statement itself has not been proved, then the recovery has no meaning at all. Because what is incriminating is the knowledge of the accused that the particular thing was lying at a particular place. It is this which has the incriminating value. So if the disclosure statement is not proved, well, evidence of recovery has to be thrown out, lock, stock and barrel. If the disclosure statement is proved and the punch witnesses have turned hostile on the recovery, then you have to look at the author of the panchanama, the police officer. Because law says that merely because he's a police officer, there is no reason to disbelieve. Again, back to square one. Circumstances and moving. Who is the complainant? Could the complainant have a motive? Could planting be ruled out? Now let us take the case where the fellow says, I was the servant in the house and I demanded wages. And the bloody fellow said, I won't give you your wages. This man has a lot of jewelry in the house, he can lodge a false complaint. The judge must be careful. The problem which we face in India is, unfortunately, well documented. The police resorts to a lot of blunting in India. Some judges say a lot of jewelry is there, how can it be blunted? We have the classic example, pre-partition, when Sir Sadilal, the second Indian ICS officer, and the first from Punjab, Mr. Singh, it's a very interesting tale for you too. He became the governor of the state of Punjab during British time. He and his wife went to Amritsar, and one day his wife said, not one day, they were there for 3 days. The next day his wife said that the diamond engagement ring you gave me is missing. Oh, it became a scandal. The governor's wife's ring got stolen from the servant house. The case had to be solved. So the senior superintendent of police and the investigating officer, and lo and behold, they asked the statement, where did Sir Sadilal get the ring from? He said, I got it from such and such diamond merchant in Chandni Chowk in Delhi, so on and so forth. On the 5th day, the crime was solved. The poor sweeper who had come to clean the toilets, his confession statement was recorded, and the diamond ring, which in 1946 costed 10 lakhs, was recovered. Case was solved. Who would believe? After a month, when Lady Sarilal in her residence was cleaning her cupboard, she went to her husband. She said, I'm the proud owner of 2 rings. I forgot that I thought I had taken the ring to Amritsar, whereas I had not. It was lying in my drawer. Sir Sadilal understood in 2 minutes. Just because the governor's wife was the victim, the case had to be solved. They went to the extent of purchasing a diamond worth 10 lakhs and planted it on the poor. If you just go on the net, put on search the diamond ring of Lady Sadilal and you will get it. It just happened that the senior superintendent of police, Mr. Imtiaz Khan, post-partition went to Pakistan. He retired as the IG. During those periods, there used to be no DGPs. He retired as the IG of Punjab Police, and the SHO, who was a Hindu who remained in India, he suffered a dismissal from service. In fact, if you read Munir's book on the law of evidence, he says this is a misery which the Indian police has brought upon itself. They resort to a lot of blunting. They get into a lot of confessional statements, and there lies the problem. And that is why the courts have said, be a little, very, very strict about it. But there is always a judicial conscience. And let me tell one truth now. That truth is, somewhere after you look at the entire evidence, your conscience tells you where the truth lies. And a judge goes by his conscience. He goes by his conscience. And let me tell you another thing. What you find instinctively to be correct is always correct. And what you contrive towards correction is wrong. Once your instincts tell you what is right, then it's all a matter of your judgment skill, that how well you can express yourself, how do you see your evidence. And that's what I tell judges, write brief judgments, write like Lord Denning. The plaintiff is Lady Smith. Stop. She is a housewife. Stop. As all others housewives do, she buys the groceries. Stop. She went to the grocery stores, bedless stores, stop. She bought a can of peas top, which I am told at about 200 peas top. As she opened the can, she was horrified. Why? Because she saw a worm coming out. Why can't we write like that? Thank you.
Thanks, my lord. Chetan, this question answer section we are going to end.
Yes, sir.
Before closing this, I seek pardon. I am saying, excuse me kindly, the remaining viewers who have posed the questions, and I must thank all of you for posing the questions. But I express my excuses for not taking up those questions, mainly because of the paucity of time, and secondly, many questions are already answered during the session. And now I take this opportunity to express my vote of thanks Honorable Sri Justice Pradeep Nandrajog sir. Sir, we are aware we had the opportunity at the Academy to hear you, and we wanted that this knowledge should be disseminated to our brother judges and sister judges also. And within a short notice, Your Honor has accepted our request and invitation and delivered very, very beautiful lecture. In fact, it is the skill, Your Honor, which is possessing to communicate the things in a simple manner. Thank you, my lord. On behalf of the Academy and on behalf of the participants, I express my thanks, sir.
Thank you, Mr. Singh, and thank you, Mr. Alvira. Thank
Sir.
you all, and
Sir.
thank you, and thanks, of course, to the viewers who suffered us for an hour and 45 minutes.
Sir, I think I would like to also thank as a moderator.
Chetan, just a minute. I would like to thank our Honorable Chief Justice and our Patron-in-Chief of this Academy and our Honorable Officiating Director and our Honorable Lordships who have encouraged for this kind of webinars and who wanted to maintain the quality of these webinars. And I also express my thanks to all lordships from Sri Lanka and their Judicial Commission members for making this facility available to their judges, and they have sent some compliments and a special thanks to our today's guest lecturer, Sri Pradeep Nandrajog sir. I am communicating their this thanks, and sir, I also express my thanks to all the judges in charge of the state judicial academies and their directors and their teams who have made this webinar available to their judges. And I express my thanks to our Registrar General, our Registrar Legal, CPC, and all in the registry who made this coordination, this webinar a very well coordinated work. And I express my thanks to all the principal judges of all courts, district courts and ex-cadre courts from Maharashtra and all other states also. And I express my thanks to my brother judges and sister judges, and I express my very special thanks to the master trainers, not only from Maharashtra and all other states, who helped other judges to solve the technical problems which arose because we are using a particular software. And I express my thanks to the system administrators, registrars, and the staff of the district courts who made this possible by making the facility, connective facility for screening in some of the district courts. And I especially acknowledge and express my thanks to the SCC Online, the management, Senior Malik and Junior Malik, Karan Malik, and their Vice Chairman, Mr. Sanjay Kapoor, and anchor, my co-host, Mr. Chetan Singh Shergill, and his entire team. They were in fact put to a very lot of stress, I understand, because we gave last minute call to them to connect more persons. I think, sir, 4,000 people are connected.
Sir, they were at one time, they were 3,000 something connected.
Sir. So it was a Hercules task to you, sir. Thank you very much. And I express my thanks to my teammates also. And with this, I conclude my vote of thanks, and with a promise again to come back for another webinar, of course, with the help of the SCC Online. Now, over to you. Thank you all.
Thank you so much, sir. Thank you, Nandrajog, sir, for enlightening us through your wisdom and especially through the storytelling techniques. I think it's almost 2 hours, but I think the storytelling techniques was so engrossed. I think all of us were so engrossed. So I think one of the best sessions that I have attended personally, sir. And I hope to see you and host you again in the upcoming webinar, sir. Thank you from the SCC Online family. Thank you so much, Yalagra, sir. Thank you to all the learned members, the lordships, and from the judges from other neighboring countries. Thank you so much.
Thank you.
We will conclude the session now, and thank you everyone for joining in. Sir.